Hi folks, welcome to the first working clip on the Mediation Vblog project site. I'm Jeff Sharp and I'm here in Wellington, New Zealand with my friend and colleague Ian Gordon, who's kindly agreed to be the first guinea pig. Ian's a go-to litigator here in New Zealand, travels all around the country and uses mediation a lot. And I've asked him perhaps just to tell us a bit about what he looks for in a mediator. And Ian, be absolutely frank. There's a lot of people would like to sort of get inside the head of some litigators and see how we do get on the shortlist. So, how do you start choosing who you're going to use?
Okay, well, the areas in which I litigate mainly are employment law and environmental law. So I'm interested in people with that experience, but particularly with litigation experience in those areas. I prefer mediators who are either ex-litigators or are currently still involved in litigation, because they've got some sensitivity to my client's needs and what can happen if we don't get a resolution and find ourselves in a court process. I find litigators who are guessing about those kind of outcomes are unhelpful, and I prefer not to use them if I can.
Do you find litigators sort of get in the way, ex-litigators get in the way of your job? I mean, do we try and second guess you? Do we try and impose our view of quantum or liability on you? How do you find that?
It's only really been a problem, Jeff, when the law's moved on from the last time the ex-litigator was dealing with a particular issue and they're trying to impose outdated views on my client or indeed on me in a private session. One of the other things that's really important is a mediator who has been a client manager in a past life,
yeah.
who understands the relationship that I've got to have the next day with my client, and who can respect that and not do anything that undermines that. The kind of example that I've encountered is a mediator who has read the latest decision from the appeal court on a particular subject that is relevant to the mediation or germane to an issue, and they, to impress the parties or to impress legal counsel involved, will spit that out during a mediation session and without even realising it may undermine my relationship with my client. Especially if I'm not across that particular decision, and ironically in those circumstances sometimes those decisions aren't even relevant, but the way it makes my client react to me and how I look in front of my client can be difficult, and that's something that I'm sensitive to. It's important to be, not to be oversensitive about that, but yeah, it's significant to me sometimes.
And tell us, does the client listen to the mediator more than you sometimes? So if the mediator says, look, you're going to be pushing this uphill or pushing that uphill, or this is going to be difficult, do you A, mind the mediator saying that, and B, does the client kind of listen to the mediator even though you've said that weeks prior?
Yeah, I don't mind a mediator saying that at a certain time in the process, but I prefer it if the mediator is saying, look, Ian will have told you that this is going to be challenging, or that it depends how the evidence comes out on the day, or how you perform under cross-examination, that any number of machinations are possible on the day. I prefer it if a mediator says that rather than expresses their own views about what snapshot of the evidence that they've encountered and how they understand it.
Yeah, thanks Ian, that's really useful. Well, that's the first kind of clip. See what people think. Be great if other people posted. Pretty easy. We're just doing this in front of a little webcam on the top of my laptop. Anyway folks, speak to you again. Thanks very much. Thanks for listening.